Hello friends, in the series on the income tax cases, today we will discuss a very important case in regard to the limitation period for passing the assessment order by the assessing officer as per section 144C subsection 13. In section 144C subsection 13, the time limit for passing the assessment order by the assessing officer is 30 days from the end of the month in which the dispute resolution panel directions are received by the assessing officer. The moot question before the tribunal in the present case was that what should be the date of receipt of the DRP direction by the assessing officer, whether this will be the date when the DRP has uploaded the direction on the ITBA portal, or whether it will be the date when the assessing officer receives the DRP direction through mail, or it will be the date when it will be reflected in the work list of the assessing officer. This case is very interesting and this matter has been decided by Delhi ITAT in the case of Hyundai, Rotem Company, Indian Projects Offices versus Assistant Commissioner of Income Tax, International Taxation. This case is reported in 122 ITR Tribunal at page number 178 and the date of the judgment is 18th November 2024. In the present case, the assessee is a Korean company and the case of the assessee was referred to the transfer pricing officer. The transfer pricing officer passed its order and the assessee filed its objections before the DRP. The DRP issued the directions on 24th May 2022 by uploading the directions on the ITBA portal. So, if the directions by the DRP are issued on 24th May 2022, then as per section 144C subsection 13, the assessment order should have been passed within 30 days from the end of the month in which the directions are uploaded on the ITBA portal, and the limitation date was becoming 30th June 2022. But in the present case, the assessment order was passed on 1st July 2022. So the assessee was contesting its case on the ground that the assessment order is time barred. When this matter came for hearing before the tribunal, the revenue contended that in the present case, there was no communication of DRP order on its email ID. The revenue further contended that in the present case, the manual orders of the DRP were not visible in the work list of the assessing officer. The revenue further contended that the assessing officer was notified on the ITBA portal and the DRP order reflected on the work list of the assessing officer on 30th June 2022. And accordingly, the assessment order was passed by the assessing officer on 1st July 2022. So the assessment order is well within limitation date. When the tribunal heard the matter, the tribunal said that in the present case, the time of dispatch and receipt of the electronic documents to be ascertained by reference to the Information Technology Act 2000, which was the basis prescribed under section 144B subsection 6 clause 5. The tribunal said that in the present case, the only important fact is the time of uploading of the DRP directions on the ITBA portal. In the present case, the directions were uploaded on the portal on 24th May 2022. So the 30 days period is to be calculated from the end of the month of May 2022, that is 30th June 2022, and the assessment order should have been passed up to 30th June 2022. And since in the present case The assessment order is passed on 1st July 2022, so it is time barred. At the end of this video, once again I am repeating the name of the case. The name of the case is Hyundai Rotem Company Indian Project Offices versus Assistant Commissioner of Income Tax International Taxation, and this case is reported in 122 ITR Tribunal at page number 178, and the matter has been decided by Delhi ITAT on 18th November 2024. Thank you, friends.